Okay, so how do we make a referral? It should be in writing. Obviously, any attorney is always going to tell you that. Try and clearly present the reasons for your concern. And again, organizing your thoughts in a manner such as this will help you put that in clear reasons. Describe specific examples. And if you've done your homework, like on this slide, you've got this evidence or indications of the problem that would translate very easily to your description here. You can, if you want to and have it on hand, you can include items such as work samples, handwriting samples, and things like that. Now, all right, so parents can make a referral for an assessment at any time. Um, now, the written referral shall initiate the assessment process. So again, this with your initial referral, for the very first time we're trying to find out if they qualify for special education. If it's in writing, the law says it shall initiate the assessment process. The district does not really have another course of action other than on the very slight off chance that they think they've already got enough information to show a court he or she would never qualify, and that very rarely ever happens. That assessment process has to start. So a referral by law is defined, and this is why it should be in writing. It's defined as a written request by a parent, guardian, teacher, or even another service provider. So somebody outside who works with your child could make the request technically. School district personnel, if you need help putting it in writing, they have to help you. That's what the law says. One thing I want to point out before we move on, though, is if you're making a referral for a reevaluation, not an initial, but a reevaluation, then the school district might not have to do it. And here's why. They only have to do, by law, they only have to assess your child once a year. Now that's in a given area. So let's say back, 11 months ago, they did an assessment for speech, but that was it. Let's say it was even 2 or 3 months ago. The only assessment they did was in speech and language. And now I think, ooh, my kid needs OT. That's a different type of assessment. So as long as it's been at least a year since the last time they did an OT assessment, I can make the referral for that assessment. But if they did a speech assessment 3 or 4 months ago, a referral even in writing for another speech evaluation or assessment is not gonna require that they actually perform it, because they only have to do that once a year. Request, and it does say initial referral, but this is going to be the same for reevaluation referrals as well. Okay, now I do want to point out, for those of you who are out of state, this is particular to California, so your state may have a different timeline. So what we're looking here, when the parent delivers a written referral request, district has to, and there's no set date, like it doesn't have to be within 24 hours, but it should be relatively immediate. So within 24, 48 hours is usually when I see this given back. When parents turn in that written referral, the district has to communicate back, we received your request for the evaluations, and here's a copy of your procedural safeguards. So you should receive both of those within a relatively short time frame. But then the district has to provide you with an assessment plan. They have to put an actual plan together. These are the areas of concern where we think we should be assessing your child. That has to be done within 15 days, 15 calendar days of the district receiving your written referral request. Now, if it is received 10 days or less before the end of the regular school year, then now the plan has to be developed within 10 days of the new school year starting. So when I say 15 days, that's calendar days, but it does not count school closures of 5 days or more. Now, another little caveat here for COVID, they're considering these, well, I'm not 100% certain on this, so I'm not even going to address that. I'll double check it, and I can tell you at the next class a hard and fast rule. Things keep changing on us so rapidly. So I'm not even going to do the COVID caveat here. All right, so like I said, within 15 days of you turning in your written referral, they have to give you an assessment plan. Now, you have at least 15 days to respond or approve the assessment plan. That means they can't rush you beyond they can't tell you turn it back in 5 days. They can ask that, if you don't mind, can you try to get it back to us within 5 days? But they have to give you at least 15 days to look it over. That means you have longer if you need it. So let's assume they gave it to you within 15 days. You looked it over and you didn't agree with part of it. You send it back. Okay, you have at least 15 days to look it over. If you send it back, it's going to start this process all over. Now they have 15 days to recreate the assessment plan and give it to you. And you have another at least 15 days to look it over. Let's say eventually, maybe the first time or second or third time, whatever it is, you get an assessment plan that you agree with. Okay, I guess I'm jumping ahead of myself here. If the parent does not respond, to the request or chooses to refuse to provide consent, the district may not conduct, and again, this one is specific to initial. The district may not conduct the initial evaluation unless they seek a due process hearing to compel the assessment and they actually win that due process hearing. So that's the only way they can do an initial evaluation without parental consent. But let's say eventually you do give your consent. You approve the assessment plan. So once the district has received the signed assessment plan, a 60-day clock immediately starts. As soon as they receive it, there's a 60-day clock that starts. They have to do two things. They have to complete the assessment and hold an IEP meeting to determine eligibility within 60 days. Now let's say it's a reassessment. The same 60 days clock starts, but instead of finding out if they're eligible, they have to complete the assessments and hold a meeting to discuss what those assessments mean, what information they gave. Does that mean we change the goals or we alter the services? That also has to be done within 60 days. So to put it in, I'm going to skip some of those little things and put it in a more visual format. Here you go. The district has to complete the assessment and if they're eligible or still eligible for services, hold an IEP and start getting that document, either the initial document created and put together or amend the IEP as necessary from the information we discovered in the assessment plan. Now, one thing that I want to point out here is the school district can use other types of interventions. They can do, a lot of our school districts here geographically in our area like to do what they call an SST or a student study team. They can do that, but it doesn't change the 60-day clock. No matter what's decided at that SST meeting, it does not replace the district's duty to complete the assessments and hold the IEP within 60 days of you consenting to the assessment plan. Once you turn that consent in, no matter what other types of interventions they want to use, that clock remains in place unless you decide you no longer want it there for some reason. So they can have an SST meeting. Yeah, that's fine, but it doesn't replace this process. So watch out for that, because I have a lot of times I'll have clients come in and they'll tell me about this SST meeting. And they're like, yeah, I went there, we all talked about it, and everybody agreed that my child isn't eligible. Okay, but it wasn't an IEP meeting because you didn't have the assessments finished. You didn't actually discuss them. Yeah, it doesn't, again, just doesn't replace the clock. The clock continues to tick no matter what other interventions or processes they decide